Good morning. The Supreme Court has issued a landmark 6-3 decision that is sending shockwaves through the nation's legal and political landscape. This ruling is not just another case. It's a pivotal moment that will have far-reaching consequences for how Americans understand and exercise their rights under the Constitution. The decision is already reshaping gun laws nationwide, affecting millions of people from coast to coast. Whether you live in a bustling metropolis or a quiet rural town, the impact of this ruling will be felt in communities large and small as states scramble to adjust their regulations in response. At the heart of the case, the Supreme Court struck down restrictive state laws that gave local officials broad discretion over who could receive concealed carry permits. For years, these laws allowed authorities to deny permits unless applicants could prove a special need, often resulting in inconsistent and sometimes arbitrary decisions. The majority opinion, written by the court's conservative bloc, affirms that the Second Amendment protects an individual's right to carry a handgun for self-defense outside the home. This interpretation marks a significant expansion of gun rights, building on previous decisions and setting a new precedent for future cases. For millions of Americans living in states with strict gun control measures, this is being hailed as a major victory for gun rights advocates. Supporters argue that the decision restores fundamental freedoms and ensures that law-abiding citizens can protect themselves and their families wherever they go. On the other hand, gun safety proponents and many public officials warn that the ruling could lead to more guns on the streets and a potential increase in gun-related violence. They fear that loosening permit requirements may make it harder to keep firearms out of the hands of those who pose a risk to public safety. The decision invalidates decades-old legal frameworks in several states, forcing lawmakers to go back to the drawing board and rewrite their laws from the ground up. This process is expected to be contentious, with heated debates over how best to balance individual rights with community safety. The case at the center of this ruling, New York State Rifle and Pistol Association, Inc. v. Donahue, specifically challenged New York's requirement that applicants demonstrate a special need for a concealed carry license. For years, this standard made it difficult for ordinary citizens to obtain permits, especially in urban areas. The Supreme Court found that this requirement was unconstitutionally subjective, arguing that the right to bear arms should not depend on the discretion of local officials. This sets a new national standard, making it clear that the right to carry a firearm in public is protected by the Constitution. States like California, New York, and Massachusetts, long known for their strict gun laws, must now overhaul their permitting systems. This is likely to trigger a wave of new legal battles as lawmakers, advocacy groups, and citizens grapple with how to comply with the Supreme Court's directive. Lawmakers at every level of government are now under intense pressure to respond to this historic shift. Some are calling for new legislation to address public safety concerns, while others are celebrating what they see as a restoration of constitutional rights. Good morning. We break down what this decision means for you, your community, and the future of gun laws in America. As the nation reacts, one thing is clear: the debate over gun rights and public safety is entering a new and uncertain chapter. Justice Clarence Thomas authored the majority opinion in this landmark case, fundamentally reshaping the legal landscape for gun rights in America. In his written decision, Thomas declared that both the Second and 14th Amendments protect an individual's right to carry a handgun for self-defense outside the home, not just within it. This interpretation marks a significant expansion of constitutional protections, emphasizing that the right to bear arms extends beyond private property and into public spaces. The court's 6-3 ruling struck down laws in several states that required citizens to demonstrate a special or extraordinary need before being granted a permit to carry a firearm in public. The majority found these may-issue systems unconstitutional, arguing that such subjective requirements infringe upon the fundamental rights guaranteed by the Constitution. This decision effectively ends the practice of denying permits based on arbitrary standards, ensuring that the right to self-defense is not limited to a privileged few. Under the new standard, if a citizen meets clear objective criteria, such as passing a thorough background check, completing mandatory safety training, and meeting age requirements, the state is now obligated to issue a permit. This shift removes much of the discretion previously held by local authorities, making the process more uniform and predictable for applicants across the country. This ruling establishes a shall-issue system as the national baseline, meaning states must grant permits to all qualified applicants. The decision brings significant changes to states that previously had stricter, more subjective permitting processes, aligning them with the majority of the country. In a strongly worded dissent, Justice Stephen Breyer, joined by two other justices, cautioned that the majority's decision could undermine states' ability to address public safety concerns, particularly in densely populated urban areas where gun violence is a pressing issue. The dissenters argued that local governments should retain flexibility to tailor regulations to their unique circumstances. The dissent also pointed to America's long history of regulating firearms in public spaces as a means to prevent violence and maintain order. They emphasized that, for centuries, states and cities have enacted laws to balance individual rights with the collective need for safety. Despite the sweeping nature of the ruling, the court clarified that states still retain the authority to prohibit firearms in so-called sensitive places, such as schools, government buildings, and courthouses. States can also continue to require background checks, safety training, and other objective measures to ensure responsible gun ownership. However, the court made it clear that subjective, good cause, or proper reason requirements, where officials decide who has a valid need, are no longer constitutional. This removes a major barrier for many applicants who were previously denied permits without clear justification. As a result, the legal landscape has shifted dramatically. States must now grant permits to all individuals who meet the objective qualifications, making the process more accessible and transparent for law-abiding citizens seeking to exercise their rights. The national debate now turns to how states will implement and regulate the specifics of these new requirements. Lawmakers across the country are expected to revisit their permitting laws, seeking ways to comply with the Supreme Court's decision, while still addressing public safety concerns unique to their communities. Before this landmark Supreme Court ruling, America's concealed carry laws were a true patchwork, with each state setting its own rules and requirements. This created a landscape where the rights and responsibilities of gun owners could change dramatically just by crossing a state line. For gun owners, this meant navigating a confusing and often frustrating legal maze. What was perfectly legal in one state could be a serious offense in another, leading to uncertainty and anxiety for those traveling or moving between states. States generally fell into three main categories: may issue, shall issue, and constitutional carry. Each category reflected a different philosophy about who should be allowed to carry a concealed firearm and under what circumstances. In may-issue states like New York and California, the process was especially strict. Applicants had to demonstrate a unique or heightened need for self-defense, and permits were rarely granted to ordinary citizens. This made legal concealed carry almost impossible for most people. Most states, however, adopted a shall-issue approach. Here, as long as applicants met clear, objective requirements, such as being of legal age, passing a background check, and completing firearms training, they were entitled to a permit. This system aimed to be more fair and predictable. In constitutional carry states, the rules were even more relaxed. Law-abiding citizens could carry concealed firearms without needing any permit at all, reflecting a belief that the Second Amendment itself was all the permission required. Gun rights advocates argued passionately that may-issue laws effectively turned a constitutional right into a privilege reserved for a select few, undermining the very idea of equal protection under the law. By the time of the Supreme Court's decision, nearly half the states had already embraced permitless carry, reflecting a growing national trend toward expanding gun rights and simplifying the legal landscape. The Supreme Court's decision doesn't force every state to adopt constitutional carry, but it does set a new baseline. Shall issue is now the minimum standard nationwide. States can no longer deny permits based on subjective criteria. For the first time, the right to carry a firearm in public is no longer determined by your zip code or the discretion of local officials. Americans from coast to coast now have a more consistent set of rules to follow. This historic ruling brings an unprecedented level of uniformity to concealed carry laws, reducing confusion and ensuring that constitutional rights are recognized more equally across the nation. The debate now shifts to state legislatures, where lawmakers and legal experts are grappling with how best to implement these sweeping changes while balancing public safety and individual rights. The Supreme Court's decision ends the era of may-issue laws and requires every state to adopt at least a shall-issue framework. If you meet the objective criteria, Age, clean record, safety training. The state must issue a concealed carry permit. Subjective judgments about your need to carry are no longer allowed. For residents in former may-issue states, this opens the door to legal concealed carry for millions. States can still require background checks, training, and other objective standards. The requirements must be clear, consistent, and applied equally to all applicants. States can designate sensitive places where guns are prohibited, but broad bans will face legal challenges. The focus now shifts to what counts as a reasonable regulation. Lawsuits are likely as states test the boundaries of the new precedent. The shall-issue standard is now the law of the land. States with the strictest gun laws, like New York, California, and New Jersey, must now dismantle their may-issue systems. Lawmakers face the urgent task of rewriting laws to comply with the new shall-issue standard. Expect political battles as states try to make objective criteria as stringent as possible within constitutional limits. Agencies will need to handle a surge in permit applications, requiring more staff and new procedures. Delays or bureaucratic hurdles could spark further lawsuits from gun rights advocates. States will likely expand the list of sensitive places where guns are banned, but each new restriction will face court challenges. The legal fight is far from over. It's entering a new phase. The coming months will test how far states can go in regulating public carry. The outcome will shape gun policy for years to come. Political leaders are sharply divided over the Supreme Court's ruling. Supporters, including the president and Republican leaders, call it a victory for constitutional rights and self-defense. They urge states to implement the shall-issue standard quickly and fairly. Many conservatives now push for national reciprocity, so permits are recognized across state lines. Democratic leaders, meanwhile, condemn the decision as a threat to public safety and vow to fight back with new legislation. Governors in affected states promise to pass the strongest possible regulations within the court's limits. The political battle over gun rights and public safety is only intensifying. Legal scholars are dissecting the court's decision, revealing deep divisions. Conservatives see it as a logical extension of the Heller case, rooted in history and tradition. They argue the ruling protects Second Amendment rights from modern restrictions. Liberal scholars criticize the majority's selective historical analysis and warn of endless litigation over what counts as a sensitive place. The ambiguity in the ruling ensures ongoing legal and policy debates. The ruling's impact will be felt differently across the country. In states like New York and California, more people will apply for concealed carry permits, empowered by clearer rules. Gun rights groups see this as restoring personal safety and deterring crime. Public safety advocates and law enforcement worry about more guns in public, fearing increased violence and accidental shootings. Police say it will be harder to distinguish legal carriers from threats. Critics argue that training requirements are often minimal, raising concerns about preparedness. The debate centers on whether more armed citizens make communities safer or more dangerous. The answer will play out in America's streets and neighborhoods. The stakes for public safety and individual rights have never been higher. The Supreme Court's decision settles one question: Americans have the right to carry firearms outside the home, but opens many others. States must now rewrite laws, pushing the limits of what's allowed under the new standard. Expect a wave of new legislation, legal challenges, and public debate. Congress faces pressure to act, but deep partisan divides mean most action will happen at the state level. The future of gun laws will be shaped by how states and citizens respond. Stay informed, get involved, and make your voice heard. The next chapter in America's gun debate is being written now.